So let's bring in, along with Rebecca, lawyer and Columbia Law School professor Elora Mukherjee, who's joining us now to talk more about this. Elora, you just heard my colleague Tony DeCopel and also Rebecca mention how Justice Roberts, in closing his opinion, says that the citizenship then and now was the right to have rights to freely participate in our political community. The framers of the 14th Amendment extended that promise to every free person born in this land. What I sort of appreciate about what Justice Roberts is referencing there is not just, as Rebecca says, the decision to overturn the Dred Scott versus Sanford case and guarantee citizenship to everyone born in the United States, but the phrase that he uses, the right to have rights, which is often associated with the political philosopher Hannah Arendt, which is the idea that citizenship in this country is a gateway to every other constitutional protection that we all have. Help me understand that for our larger audience.
Absolutely. So the right to have rights allows people to participate in federal elections, allows people to have a safe life in the United States, allows people to send their children to school here, allows people to build a life. And that is so important and reaffirmed by the Chief Justice's opinion here. It's important to note that birthright citizenship is embedded in the U.S. Constitution. Its principle has been reaffirmed by over a century of case law from the U.S. Supreme Court. There are 2 federal statutes on point. There are decades of executive branch practice, and generations of Americans have relied on birthright citizenship. So today's Supreme Court decision is a strong rebuke of the president's executive order.
And so, I mean, play out the implications here. What are the implications for mixed status families right now? I mean, are we looking at a situation where this decision now sort of stands and goes forward, or could you have states chip away at certain restrictions or resources, particularly for those folks that are born to undocumented parents?
Today's opinion is critically important, especially for those families who are expecting babies right now. I'm working with asylum seekers, with those who are here on student visas and professional visas that are temporary, who are currently expecting to deliver babies this summer. And they have been so scared and worried about what the Supreme Court would do today. Today's opinion brings them relief and joy because their babies will be U.S. citizens and will be able to stay in this country safely. For mixed status families, they are not out of danger. The president's mass deportation agenda will continue to put those who are undocumented and those who have temporary status, including temporary protected status, at risk of arrest, detention, and deportation. In terms of benefits, states are prohibited under the federal Constitution from discriminating on the basis of nationality or discriminating on the basis of citizenship. That doesn't mean that states won't try those techniques.
All right, Eleanor, stand by. Rebecca, stand by. I want to bring in renowned presidential historian and author Douglas Brinkley. He's currently the humanities chair and a professor of history at Rice University. Professor, before we talk about just how broad the powers of the presidency have expanded under the term of this Supreme Court, I just want to take a moment as we prepare to celebrate our 250th birthday to talk about this ruling that we've just all been talking about. The opinion when it comes to this birthright citizenship case repeatedly invokes Dred Scott, the slave, Abraham Lincoln, our 16th and greatest president, Frederick Douglass, one of our greatest civil rights champions, the Civil Rights Act of 1866. Remind us once again why the 14th Amendment wasn't just simply a legal amendment in this country, but part of the second founding of this republic.
Well, I like the way you frame that because it really was the second founding. I mean, right now with America 250, we're talking a lot about the Declaration of Independence, and the Constitution, but they have things in them that have to evolve over time. I mean, in the Dred Scott case, this was game-changing, the 14th Amendment, and that it has to hold It is the birthright. If you're born in America, you're an American citizen, and it applies to all. What was radical was President Trump throwing, I think, willy-nilly and full of hubris, an executive order on day one saying, basically, we're going to trash the 14th Amendment. That may have scored political points with him for his base, but the problem with executive orders, you can sign them and you get a lot of media headlines. But once the courts get going, and sometimes takes a year or 2 years, they could all be thrown out. And so, our first presidents really didn't use. George Washington only used a couple of executive orders. Big one for neutrality with Europe. Abraham Lincoln had a big one with the Emancipation Proclamation. That was an executive order. It's in the 20th and 21st century, presidents wanting to circumvent Congress and take an idea that's just near and dear to their hearts. They'll do what you see President Trump do. And in the end, you're back to ground zero again. I mean, the news is Dred Scott decision mattered, and it still does. It's the second revolution in many ways. And all this is a reconfirmation that the 14th Amendment is alive and well in the United States, and it's really the backbone of who we are as a people.